Okay, so welcome back to the second session of Emilio's The Redress of Law book launch and book symposium. We have had already a quite exciting first session. I think it is getting probably even more exciting. We have 3 speakers today in the afternoon. The plan is the following one. We will hear from all 3 speakers, one after the other. The order is Joerges first, Camila Vergara second, and Angelo Golia third. Emilio will have a chance to reply, and then we will have a session of questions and answers. I must say that the environment during the first session was very civilized. I'm very happy to see that, because I was afraid that a few people might take advantage of the opportunity as a revenge. We all have had our Emilio's smiling experience, so to say, where you sit down, you discuss your work with him in this kind of charming setting, charming smile, and by the time you leave, although you're quite happy, you suddenly realize that you're bleeding, and then you discover that basically you have been stabbed. So it's quite nice to see that, although a lot of us have probably experienced that, no one has yet taken the opportunity for revenge. So well done to all. I mean, really high level of civilization. Anyway, having said so, let's start. Floor is yours.
Okay. One comment on the book of Emilio's has not been made, and I do it. He is an excellent black letter lawyer. No, it's quite amazing. And the good thing about it is that through this black letter lawyer, he's not doing the whole field, but when he writes on labor law, is precisely also transmitting the messages of the theory. So I think there is an interesting proof why we should take the law seriously. Really so. Okay, but for the rest, I explain my presence here through an anecdote. I was invited to join a project of what the Italians call IBIG, right? IBIG of Economic and Monetary Union. These 3 organizers from Poland, Germany, Netherlands invited me to write something through the conceptual foundations of the Economic and Monetary Union. I produced an abstract, I produced a revised abstract, and I insisted that one should ask whether this constitutional arrangement, this institutional arrangement, deserves to be called a constitution. I thought this would be a nice contribution, but they were angry. They were so angry. I raised this question that they didn't throw me out, but I went away. I went away and looked into Emilio's book, because I thought if anybody can tell me what a constitution is, he will be the one. And I tried to understand the book as good as I can. But okay, I have a couple of things to say which are related to his work, and it's more complementary. And fortunately enough, I have read 2 authors not cited in the book, and I think they're worth to be read. Okay, one is Lisa Herzog, working with Axel Honneth, and the other is a famous man from Harvard, Danny Roderick, political economy. I will address 3 points. The first is Emilius is unhappy with market governance. I will confirm that I'm also unhappy, but I will add what Lisa Herzog can contribute to understand the unhappiness, and maybe also to revise it a bit. I will thereafter address the process of marketization in the European Union, where we don't have really, and in a certain respect, you will see a bit more radical in the development of that. And third and finally, that's important, I will try to find a way back to democratic constitutionalism. Constitutionalism on its way back. How do you like that? Okay, I will try to do this. And my line is here, Bob Dylan, and somewhere the way out of here. Okay, market governance first. We share this commitment, and I think his characterization of the process of a shift from political to market constitutionalism is exactly capturing the essential. I like this very much. And I think I'm thinking along the same lines. I also appreciate very much his knowledge simply of the notion of economic constitutionalism. This is something which has transformed its meaning completely. He knows, maybe from Bootstroops or whatever, it is certainly true that the origin of this concept was leftist labor lawyers in Germany and later people defending the idea of economic democracy. These people have been turned around by a redefinition of what is economic constitutionalism. And this redefinition occurred under the heading or under the leadership of Franz Böhm at the time, a young guy working for the German ministry and establishing antitrust law in Germany. But he was sure, and many people were sure at this time in Weimar, that democracy had no chance. And the way to save democracy would to impose indeed a strong order on the economy. This is a very delicate issue, but one which one has to take in mind when one talks about economic constitutionalism today, and when I talk about this to my friends on the experts on the economic and monetary union, because it is indeed the case, exactly as you describe it. This is, so to speak, the alternative to democratic processes. We don't need them because they are senseless anyway, but because the real stabilizing function of law in a society and constitutional function is to ensure the proper functioning of markets. This is a difficult story, and it is not. It's much too easy to equate the strong state of the order liberals with what the Carl Schmitt had in mind and suggested. Okay, but still, it is, I think, the great advantage of your book, Emilius, that you don't go into that kind of small talk, but that you talk to from Hayek. He is the mastermind in these matters, and you can save a lot of time if you just focus on Hayek. Most people don't read him carefully. And the passage on the discovery procedure of competition and discovery procedures is brilliant. The more so since my hero Witolder has introduced this to us, and we all were struck because it was a paradigm shift in the tradition, and an interesting paradigm shift because it was a way out of the impasses of already visible problems of the democratic constitutional state, albeit one, and there Witolder was, of course, brilliant as he is, immediately aware that this is really public enemy number one from Hayek. Okay, but now let me take a little turn because Hayek has written another beautiful essay that's called The Use of Knowledge in Society. And therein Hayek has tried to make us believe that markets are unique in their capacity to collect, process, and coordinate knowledge that is dispersed in society. This is the function of markets. And this is a process markets organized. Now, this has a great knowledge, as everything Hayek does. It is very interesting. It's a seminal article, but there is a problem with it. I have invented in my naivete some counter move. I called it practice as a discovery procedure. Practice as a discovery procedure was growing out of my observation of the functioning of markets, actually, and of the battles of market participants, organized interests, and so on. And I observed that the process was not a discovery process, but was one of bargaining, claiming, fighting, and bringing this to courts, and the courts looking at that. And this is interesting because courts listen to normative arguments, and they don't simply are black letter machines. No, they listen. And what I observed is really that the arrangements in a couple of fields of studies is it's exemplary, but it's certainly with its limit of a case study, that you have something like the production of law, which you can call, we treat as a term, Fertigung, law production. Production is not as good as Fertigung, as is craftsmanship. Okay, this is how it happens, and this is what tells us something about a common common colleague. We appreciate this, Polanyi's idea about the political dimension of the economy is very much, I think, in line with my little observations that indeed the economy is a political entity. The economy is a polity. And this is something which I think is important when you talk about market governance. I will come back to this in my third section. Now, market governance in the European Union. The institutionalization of market governance is called economic constitutionalism. I've just mentioned that this concept has a long story, and its original foundational meaning by left social democrats in Weimar has completely turned upside down. And it is a process which is going on. It is widely appreciated that indeed in the post-war period, Germany's social market economy was not as beautiful as our common friend describes it. It was more problematic, and it is certainly true that this idea of a social market economy got under stress in Germany. Anyway, it is giving away, and this I think is also an interesting term that Germany took. In post-war Germany, the bad traditions came back, and one of the bad traditions was organized capitalism. This was not a defense of a democratized economy. It was really organized capitalism serving economic interests and big business and so on. And Ludwig Erhard, the poor guy, had to experience the downfall of his project of antitrust law and so on. Now, people, and now again, it is very delicate to say something positive about ordoliberalism, but what these people did, in a way, it was at the end very tragic, but what they had in mind was, okay, in Germany, we observe the return of the old kind of organized capitalism, which has helped not only in the First World War, but also in the preparation of the Second World War, to merge economic power and state power. Now, what they thought and they believed in, at least the leading guys like Franz Böhm, we go to Europe. In Germany, they had lost before the German Constitutional Court in two famous judgments. The theory of the economic constitution was declared to be invalid 2 times by the German Constitutional Court. A clever ordoliberal says, aha, then I do it in Europe. In Europe, I have a framework and I have an institutional configuration with the overmighty court, an antitrust division, which nobody understood except Germans. We had a Kartellamt, nobody else had. And people know the people from the Kartellamt were brilliant. You see, the German Bundeskartellamt in Berlin. And the commission was dependent on these guys. And they worked on that, and they did a couple of things, and then not everything they did is simply, yeah, it is controlling the market governance, if you want to. This is the idea of property law. Now, this went on, and the process went on, and now I distinguish between 7 stages of this process in Europe. I'll spare you that, but I agree that the real highlight of everything is the MU. This is the consummation of market governance, people say, and I would say it is something now where Lisa Herzog comes in. I have not yet introduced her observations on what happens in markets and how she analyzes it. And she says the markets and the economy need three types of knowledge. One is the production of information as markets do it. Then you also have this element of epistemic knowledge. You need experts for so many things. You cannot assess vaccines without expert knowledge. And then you need deliberation or contestation over these matters. And these three types of knowledge form, in her opinion, the background of a democratic society. And so I think that is an interesting critique of the, say, a bit superficial notions of market governance. Market governance is more political than it looks like if you take the synthesizing of these three types of knowledge into account. Now, I say this happens at the national level, and it also happens. Sorry. Oh, no. How do I get this out? Oh. And in the European case, I have done a couple of case studies where one can really see how this machinery of European law is trying out, giving it back to the national judges, looking at it again and so on. But this of integrating of knowledge and different types of knowledge in the final decision making is happening. This is not what happens in the economic monetary union. And here's something else which is really very frightening. On paper, you can say that the economic and monetary union is the consummation of market governance. And why? The two principal rules, the no bailout principle and the ban on monetary state financing, of which we just talked with respect to Greece, but it is, the idea is, in order to maintain the pressures on national constituents with fiscal policies, you have to expose them to market governance from the international level. So market governance replaces the political processes in member states. This looks like market governance poor. But if you think of Lisa Herzog's basic argument is markets don't deliver and unable to deliver the kind of knowledge regulators and courts need when doing their job. It's not what markets can do. There you have to insert all sorts of other knowledge. And the negative proof of what she says is that it really did not work. The markets don't, or these rating agencies. This is guesswork. Sorry, people should respect rating agencies. They're well-paid people. They're very intelligent and so on. But the point I want to make is the failure of these processes to the failure of market governance has promoted the turn to technocratic governance and to very authoritarian form of Draghi, brilliant, great. What the hell is going? The markets don't understand what is correct. I am Draghi, tell you. I will do what is necessary, basta. This is, of course, the downfall, I think, of the idea of economic constitutionalism. And the point I want to make is this is not the consummation of the market governance, but is the destruction of market governance through these mechanisms. It is not true that the markets govern what the European monetary policy does. It is much more discretionary and also authoritarian governance in Europe. What has the law to do with all this? It is all law. There are thousands of pages of law, if you call it law. The point, however, is that what is at the same time looking at an ever-growing body of law is coming upon us, thousands of pages. And when it came to court, the European Court and the German Constitutional Court had these wonderful fights. The point is that I do not now defend the German Constitutional Court except the two dissenters in the rotating decision. Very brilliant. But the point is that what the European Court did is so outrageous. To simply say this is something which needs expertise. Monetary policy is the field of where expertise must govern. The expertise resides in the ECB and nowhere else. So this is why do lawyers accept such nonsense? I don't know. But this is a power play, and whatever you say when you start to say, well, didn't the German court have a point here? So you're immediately outlawed, so to speak. Not again. Stop this. So I'm ready in a couple of minutes. Now, this is now the way out of here. You see this disaster and you wonder what can happen here? Now, the recipe, I have a recipe, I call it democracy enhancing conflicts law. If Emilius would look at conflicts law, he says, isn't that very close to constitutional pluralism? And I would say no, but we can look at that. What I find very interesting is the man I mentioned, that is Danny Roderick. He should really play a bigger role in European studies. He is famous. He's a big shot in the United States. And his books on globalization are indeed fantastic. And the one I refer to is just one theorem he has, as he called the trilemma thesis. The trilemma thesis says you cannot reach in any polity three things at once, which is respect autonomy of the democratic processes, pursue economic globalization, and if you try to pair economic globalization, democratic politics, and national autonomy, you will run into a dilemma which cannot be resolved. He calls this a trilemma, and he says, and this I think is a point where European lawyers should listen, although he's only a political economist, but a good one. And he says, Europe has either to really go ahead and build up a federation with political power and political respect, or has to dismantle the euro. And that is a strong thing nobody wants to hear. But it is his analysis of the trilemma. And now I will tell you that he has a very good point by underlining that our two master thinkers in Germany, namely Jürgen Habermas and Wolfgang Streeck, arrive at the same point. Habermas, ever since his early debate with Peter Grimm in the European Law Journal #1, 1997 or so, 1997, defended against Grimm the idea of a European constitution. Does Europe need a constitution? Habermas asked it, he said emphatically yes. And this he repeated for 20 years. One of the last articles is in 3 languages, how the democratization of the European Union is possible and how it can be accomplished. A wonderful theoretical construction. He has offered but one which does not really attract too much political support because nobody knows how to implement this. This is the co-originality of European citizenship and national citizenship. Wonderful ideas. It doesn't work. The other side of the game is Wolfgang Streeck. He does not say we should move towards the Europeanization of our constitutional constellation, but we should defend the potential of the nation state to defend democracy. This is not a simple argument, but Streeck is a bit overdoing it. So then my point here is a constitutional point. I think it's also related now, Emilius, to your critique of the European constitutionalization. And so simply the observation is democratic governance under conditions of interdependence is not possible unless you cooperate. So a national democratic authority will always affect its neighbors and will have to resolve problems where they don't have the only say. So the way out is to come back to our friend Polanyi. At the end of his great transformation, the concluding chapter, he says, the future is the respect of diversity plus cooperation. Now, this is, of course, again, a dilemma, because if you respect the autonomy of autonomous will formation and at the same time insist on economic cooperation, then you don't know how it comes about. Now here, Dani Rodrik comes in with the concluding argument, which I love because it is so close to what I have in mind with my democracy enhancing conflicts law. He is informed by a couple of political scientists, Robert Keohane, Steve Macedo, and Roman Kravchik. They have developed this idea, and it's a critique of the potential of globalization, global governance. Global governance exists, but it is a very problematic thing. All these authors say, and Rodrik agrees. And his point is the main failures of governance have their origin in national mistakes. So the correction of globalization failures has to start down at the national level. So he wants to impose via, if you go to the European Union should have the power to control the democratic quality of decision-making process of national level. And this should be the basis for cooperation. A very daring idea, but at least one which I love and would think it is a way out of this trilemma Rodrik has pointed out, but also for this totally absurd confrontation on the one hand, Habermas, the dream of the European Constitution, Schreck, the defense of the nation state. There must be some third way out. This is why I cited Bob Dylan. So we're way out of it. And this is democracy enhancing constitutional. Okay, basta.
Thanks a lot, Christian.
Yeah.
Now we have Camila. Camila is a Marie Curie Fellow at the Department of Politics at Cambridge University. And I just want to highlight before giving her the floor that she has written a very influential book on systemic corruption, where I think she has an idea of constitutional strategy. It doesn't really dovetail with the needs. But anyway, Camila, the floor is yours.
Thank you. Thank you, Marco, for inviting me. Thank you, Emilios, for writing this great book. So first of all, I want to say that I brought my little dagger, so I will be inflicting some pain. I hope it is not that terrible and you find it amusing. A little bit of incivility coming from the Global South, from this very European book, I would say. First, to say that this is really a great book in terms of the depth that it covers, the intuition behind it, and the aim of it, that I read as trying to hold the political constitutionalism, guarding it from the market forces, which is a very good aim, I would say. I will begin by stating from where I am bringing my criticisms. So coming from very realist point of view, from the Global South, in which a region, Latin America, where equality has never been something normal, I would say, for the constitutional structure, has always been structures in which the few are very few and the many are all oppressed and precarious, in which constitutionalism was always seen as an oligarchic way of freezing the status quo and allowing the few to reproduce within the system. So from that point of view, I bring with my criticisms to the part of strategy, because Marco told me to please center on the strategy on the last part of the book. So First of all, the strategy that last part is focused on the defense of political constitutionalism against market deformation. Here already I have my point of view, in which from the history of at least Anglo-Saxon constitutionalism, the constitutional structure was always market-oriented, in the sense that it was always there to preserve private property as a central individual right, which cannot be trampled by the state, and the state was seen as an agent that would come and undermine this pre-political right, which is the right to private property. So starting from this perspective, this is already an idealist position in which we can, and it's very European, I understand, that there was a time in Europe in which there was more equality. Today, and just to quote the last report of wealth inequality in Europe, the richest 10% today is the owner of 50% of the wealth, while the 50% in the bottom income bracket only has 4% of the wealth. So this is clearly a system, at least the legal system has allowed for the accumulation and preservation of inequalities across the board, even in Europe, which is the most equal region in the world. Okay, so from here, the idea of market deformation of what? Are we really understanding the Constitution as an ideal structure, or are we projecting our ideals, understanding of what law is supposed to be in these orders that are not really ideal to begin with? I welcome very much the reintroduction of critical theory as this deficit that is experienced as alienation, as a point of view that has to be outside of the system in order to criticize the system, and that separates reform and renewal from rupture. Okay, this is very important, since many of the reformist constitutional thought has been into the margins and into creating some tweaking here and there, but not really changing the realm of appearances, if you will, and the way that politics is done. So here, Emilius offers a critique, I would say, of the deliberative situation, criticizing Habermas, and this idea that is already, when we have this deliberative situation, we already have a presupposition of these relations of recognition and equality, right? So there we already have that kind of a ground that is very ideal. And here we need to question what are the well-grounded procedurally sound norms that are emanating from the system. And this cannot be done dialogically. It has to be done through it cannot be done through a hierarchy, but dialogical in the terms of the people and the relation with the system, with the outside, and with the reality, which is never, really outside, as Emilio points out, is really already being used in order to renew the system. So here, Emilio does as a very kind of counterintuitive way, I would say, from a very radical perspective, of using the tools that have been used in the past to preserve an equal, constitutional framework that works for a few and not the many, but to defend what this political constitutionalism is. So here he brings militant formalisms, and there's two kinds, homology and deadlock, as tools in order to preserve a political constitutionalism that would be, ideal in a way, and would be in relation to reality, and would not allow for the market to erode those principles that we are already entrenched. So with this, basically using these tools that have been used for even furthering, I would say, the market penetration of constitutionalism to fight against it. I was here puzzled, I have to admit, in that you brought the case of Chile, this last part, because I thought that you were going to bring it in the original, in the part of the market constitutionalism, since the constitution of Chile, made under dictatorship, was the economic constitution par excellence, was made to insulate all the constitutionalized market structures from the people. and therefore I would say it would have been deployed better at the understanding of economic constitutionalism rather than in the strategies of this militant formalism, because in a way it acts. I didn't really get how that allows you to think forward in that direction, because if we think about Chile in that moment, it was a very unequal country, and the dictatorship, what it did, retrenched the state, and then created this binding mechanisms and this frozen, basically, state to and didn't allow the state to engage in activities in order to redress the demands that were coming from below. So in a way, it is kind of an extreme case of economic constitutionalism, and all the formalism that has been brought about until today, even with the pre-constitutional, pre-enactment of constitutional review before the law is even given, is not applied, sorry. So even a pre-censor of that law has been applied in order to create a constitutional framework that does not move, that even if you change it, it's not allowed to change at its core. So in this way, if we think about the homology as a tool that privileges, as you say, redundancy over a variety and diversity and the new, then we can see that we can, if we have an ideal constitutional framework, we could really control innovation. We have controlled innovation from within, and in this way, there is reform without allowing for the erosion that could come from the outside of the market. And then the other is the deadlock, which is basically locking in the solutions to the problems, and it's the entrenchment of values and hierarchies that they are then deployed in order to hold the line, basically hold the line of this erosion that comes from the market. And here it is interesting to know that there's this idea of deadlock allows for the immanent critique. In a way, in order to have the immanent critique without bursting the unity of the legal system, you need to have these hierarchies and these procedures in place in order to play within that game and stretch, I would say, the boundaries of the possible without breaking the system as a whole. So it allows for, as you say, the recalibration of subsystem boundaries, which is very important. And here, justice as a concept is brought to as a way of as a subversion of the path dependency of the tendencies of the system to close within itself and to deepen, I would say, the more the tendencies of the system. And here there is something that you didn't even mention in the book, I would say. I would need to read it again to see if it's specifically named, but there's no mention of oligarchy here. There's no mention of the oligarchic tendencies of the system, of what Robert Michels would say, the iron law of oligarchy in all institutions, in which you have, even if you have an ideal system, it tends to degrade and become the power concentrated in very few hands, from Plato to today, right? We have this tendency of the system. It doesn't work, and I would say here with Plato, it doesn't work both ways, kind of like more democratizing. It works actually for more oligarchic power more and more all the time, in a way. So there is no, in the book, there's no special mention to this tendency of oligarchization with the system, and therefore the connection of social justice with this against this oligarchization, I think would have allowed for a deeper analysis and more interesting in terms of what is the spillover that you are bringing, this idea of how the system reroutes all the justice demands and the spillover to the system again, into the legal system, and subversing law from within. So this idea that the law subverts itself within its own languages. And one of the things that it called my attention is that in this political constitutionalism, there is this idea that the constitution works for the public interest. And there is this very normative, explicit or tacit ideal that the constitution must work for the public interest. However, if we see many of the constitutions, there is not clear, even if it is declared, there's not clear aim at this public interest. It's more as an interpretation of how things should be. And here the problem is that, again, with the Constitution of the United States specifically, that individual rights tend to trump the public interest over and over again. And the high courts are there to preserve, and from a theoretical and practical point of view, the individual rights of citizens against the state. And therefore, the public interest takes a secondary step when it comes to individual rights, which makes, I think it needs to be problematized, this idea of public interest, both in theory and practice. Then I would like to go to the second and third parts of the chapter, of that part, which deal with rupture. And here is interesting because you bring, and I think this is more the closest part to my own work. So I feel happy that someone else has been, working on this kind of reintroduction of constituent power, aka democratic power, into the system, and in a way reconfiguring the space of appearances, and not mainly trying to have a voice within the state, as Rancière would say, but to actually change the paradigm itself by allowing the people to burst into the scene, right? That it is something that happens in the event as a form-giving moment. And here you take Luxembourg and I think and Sorel, and as a Luxembourg scholar, I resent that you didn't focus on the last works of Luxembourg that actually give a more line to what this constituent process or moment or energy would look like, which is the Spartacus League and all this, the idea of the councils, where she puts forward what it should be done in terms of infrastructure for this constituent power, for the power of the people, the power of democracy, really, to emerge autonomously and spontaneously, right? So you focus on the must strike, which, of course, as you correctly say, it is the moment of radical withdrawal, and is the moment of the bursting into the scene, and to opening up of the changing of the system. And coming from Chile, this is the moment that we are in which the mass in October 2019 really came out in the streets, and it was a moment, an event that gave the opening to this new constituent process. However, the process was not mainly in the streets, but it was also in councils and squares where decision-making was made, where people came together, and they're still coming together in order to give input to the representative assembly. So there is a duality between the mass strike and the council system that you see in Luxembourg's work, if you see the whole work until the very end. This is important. And in terms, I think something that you brought from Lumen, and I think it is very interesting, and also kind of ties with the COVID and all this science and medical talk, is that how the system adapts to the new, to the strange, to all the new things that burst, and is about the immunization. So the idea that the system does not change against something, but with something, that you need the strange in order to adapt, in order to gain new energy, that the system actually needs this outburst, that but it actually ends up phagocytating it, kind of including it and changing it, and it changed in this process. And I very welcome the engagement with Hans Lindahl's illegality and this impossibility of containment. I think it was very accurate, your understanding of the illegality that is only being able to be recognized through the duality of legality and illegality, as kind of a saying that illegality is illegal, and is the only way that we can comprehend this kind of outside that tries to be antagonistic to the system. And then in terms of the third strategy or the third lens that you bring in order to preserve political constitutionalism is the idea of the material constitution as an interplay of semantic and structures and the creation or the understanding of this different network of concepts that are deployed as what Foucault would call the dispositif. And here you bring in Epicurus, which is a thinker that has been from the beginning in this material understanding of the constitution and the order. One thing that I missed that you might have been keen to analyze is that actually Marx wrote his doctoral dissertation on Epicurus and Democritus. So Epicurus, this Epicurean philosophy and the atomistic understanding of the world and the swerve, this idea that there is free will, that there is this free particle, this free movement that we cannot really explain through the patterns, but it arises spontaneously in order to create new patterns. This is something that cuts across also Machiavelli. So Machiavelli was also very informed by Epicurus, Lucretius, and the nature of things. So I think maybe for future research, something that it would be worth to grapple with in more depth. Something that I would like for you to explain a little bit more is how this material constitution brings visibility and black boxing. There's something that you say in 543 that you say materialities run alongside the processes of meaning formation as apparatus, assemblage, or network, alternatively leading visibility and black boxing. They are the forms that Fortuna takes in the semiotic field of the Constitution. So if you can explain a little bit more how this process works in terms of examples that you can give us as how these materialities can bring visibility and black boxing, that would be very helpful. And also, I think that was incredibly interesting your use of Negri and the labor constitutionalism as the antinomic foundation of the material constitution, as something that is supposedly central and principal in the constitution, but is not really materialized. So the only way to make it material is to disrupt it. I find this very interesting and kind of against the formalistic thinking that and aspirational thinking that undergirds constitutional theory. So I think I completely agree with you in terms of what is necessary, which is as I see it, the constitutionalization of contradiction, of the swerve. So how can we bring within the constitutional structure this, the new, the strange, without allowing the strange to break the system, but as innovation that is not really controlled as a mere renewal, but it is every time remaking itself at a pace that is tolerable, and not the permanent revolution of Negri, but a more controlled innovation within these paradigms. I find that very interesting, and I completely agree. And lastly, some minor criticisms. First of all, you have a very conservative interpretation of Hannah Arendt. I agree that with part of it. However, I myself have been working on one of the most controversial texts on revolution that actually ends up with not institutional infrastructure per se, but by the council system. The idea that we need spaces that are not really structured, pre-structured, but where the new beginning can actually take place. A place in which innovation without limitation, the only limitations from the actual interaction in praxis can arise. So I have been working on this. Also, James Muldoon has been working on this, very interesting. So that is worth, I think, at least to moderate the conservative view of Arendt. And I agree that she is very conservative, but at least aspirationally, she wrote these things that are also very radical in themselves. I already addressed the narrow reading of Luxemburg, but I also want to point to the very partial reading of Machiavelli through Althusser, because Althusser only is centered on the prince. However, if we look at the Discorsi, which is the 3 volumes that Machiavelli wrote on the Republic, then we see how he tries to constitutionalize the swerve, how he tries to not really reform, but bring in a dynamism, something that really is going to update the system by bringing the constituent power in a periodic manner, and not having a permanent revolution, but actually having it in a periodic manner that could update the system without having to be limited by the current rules of the game. So bringing the people this uncertainty back into the system, and not really stabilizing as we have now. And just one minor error in the Chilean example is that first of all, one of the most important things that the Constitution did with the electoral law, the binomial system, was to overrepresent the minority. This is what happened. It was a calculation on forces. So the idea is that you wanted to have two different forces in the political system, bringing stability, and the right wing always had a minority of the votes, around 43%. So therefore they wanted a way of having this veto power and having an equality between the left wing forces and the right wing. So therefore they devised this method in which if you had 2/3 of the vote, you would elect two people instead of one. So therefore you can bring a kind of a veto points in the Congress. This is one of the most important things that were the last things to change in the Constitution. And then actually the Socialist Party came to power in 1999, not 2006. Ricardo Lagos, who famously passed around 30 or more reforms to the Constitution, then he signed his name into the new Constitution, saying that the Constitution of 2005 was a new Constitution and had his name on it. And today, where people are campaigning in favor of the new text or against the new text, actually Ricardo Lagos from the Socialist Party has come against the new text, saying that the text that he revised is his, basically, and is fine, and we should stick with it. So the Socialist Party has had a very controversial role. And finally, I mean, with this I end. In terms of the orientation of the Constitution towards the market, this is not something new. I take from Montesquieu, for example, who argued that risk-taking in society and the inequality of wealth will increase in places in which there is a republic, in which the law is secure, in which there is no or there is less uncertainty. So therefore, the idea of the law or the order in relation to market society is to stabilize the uncertainty in order for the market to thrive and for the risk-taking to take place. So this is something that he brings very early on, and something that is really then constitutionalized in the United States. So I understand that your book is oriented to our European politics, but this counterpoint with, you know, the more the American and the Latin American experience, I think it will be fruitful for future research. Thank you so much.
Thanks a lot, Camila. So now Angelo Golia, who is a fellow at the Max Planck Institute and the author, very prolific author of several publications. I will just mention at least those expanding and deepening our understanding of societal constitutions. Angelo, the floor is yours.
Thank you very much. And yeah, I'm particularly happy and I would say even emotional taking the floor today. And I really would like to thank both Marco and Christodoulidis for giving me the opportunity not just to read this book, but to engage with it in a more meaningful way. So I would start by saying that the Redress of Law presents an original, brave, and ambitious critical theory of constitutionality. It's original as it combines elements of very different and often regarded as mutually exclusive lines of law, and productively re-elaborates them. From Luhmann, it takes the main framework to understand constitutional normativity and the emergence of different systems of meaning without his analysis of the political. From Teubner takes strategies of militant formalism without constitutional pluralism. From Foucault, genealogical analysis without the decentering of the subject, and all this with the humanism of Saussure and Simone Weil. I think it's a demonstration of how to do militant scholarship in the best sense of the word, without cherry picking and self-referentiality. So in this sense, it's a work of intellectual honesty and generosity. And it's ambitious because it aims to score points both in critical theory and constitutional theory. Two camps, the two receiving camps that funnily enough have been particularly in different ways influenced by Habermas and Habermasian discourses. And speaking of this, I would say his critique of Habermas is one of the most powerful of the past few years that we have seen, especially from within European critical theory. And this critique reinforces other critiques, of course, formulated, for example, by, I would like to recall especially Nancy Fraser. And why? Because her critique of Habermas was based, among other things, on his alleged over-reliance on systems theory. The over-reliance of Habermas on systems theory was one of the reasons why Nancy Fraser criticizes Habermas. And this gives an idea of how ambitious Christodoulidis' move is within the intellectual field of critical theory. Here, however, I would like to bring to life two stone guests within critical theory. So the first one is the concept of intersectionality. Christodoulidis seems to somehow follow Luhmann's overall disinterest towards the medial substratum and real-life conditions of social communication. But isn't this the concept of intersectionality together with space actually relevant to his work? In my understanding, Christodoulidis focuses and aims to mobilize the practice, the experience of labor. In this framework, these and not other experiences are the beating heart of the processes of becoming a subject, reclaiming contingency, rebuilding the political sphere, thinking the given otherwise. Another reason why I recalled Nancy Fraser in particular is the fact that, like other critical feminists and feminist thinkers, she draws upon postmodernism and works with the concept of intersectionality, never really discussed in Redress of Law. So if the problem of global capitalism is not just the competitive alignment of national systems of labor protection, but it's also the pluralization of the social processes that create self-subjectification, right? Which makes more difficult to federate movements, to reclaim contingency, to escape single issue politics, also for workers. If this is part of the problem, the reader is left with at least a curiosity on the absence of this engagement, even a critical one, with the concept of intersectionality. And this question is even more interesting for me because this concept, especially in US scholarship, has come to dominate the theoretical frameworks of industrial relations. So that would be my first question to the author, especially when it comes to the relationship between unions and migrant workers. Another stone guest that I would like to bring to life is space. Here again, there's a bit of Luhmann's disinterest towards the medial and real life conditions of social communication. But isn't the spatial dimension relevant as such to a critical constitutional theory? The author, of course, discusses space, but at a very, I would say, abstract level of analysis when he discusses, especially Linda's theory of allegality, the borders, right, of legal orders. And what does not seem to enter the picture is how law may strategically participate in the reconstruction of the spatial conditions that made or make possible in the first place strategies of redress, the reconstruction of the symbolic spaces of relations of power. Do really Lefebvre and Deleuze, among others, have no role to play in a critical constitutional theory at the age of globalization? Especially Lefebvre's early rural studies on the French resistance, for example, or the book of 1965 on the Paris Commune, which had some influence on the leftist movements of the 1968, have nothing to say to your theory of critical constitutionality. This question, I think, is even more interesting, given that many of the concrete experiences recalled in the Redress of Law refer to very concrete spatial dimensions, and namely the city and the public. So how the market capture of the spatial conditions for labor struggle can be captured in a new critical constitutional theory. Now, turning to systems theory and societal constitutionalism, that I understand is the main reason why I'm here today, the Redress of Law will certainly, I think, become a point of reference in an ongoing debate over the critical term in systems theory. Discussion within both systems theory and critical theory about the sustainability of this term, as we all know, is quite heated. I think that this book exercises a gravitational pull, as the author would say, in a certain direction. It shows that systems theory may provide guidance to strategic actors to the extent it can be used to force the appearance of the contradiction and de-verify the given, especially when this appearance is associated to strategic variations in social communication and the unveiling of contingency. In this sense, this book contributes to humanize systems theory by systematizing and putting to use elements that are only sparsely present in both Luhmann's and Torbner's works. Societal constitutionalism in particular may offer strategies of formalism, as Christodoulidis puts it, in order to guide the selective withdrawal of certain areas of social action from the logic of the practice. In this sense, and this is a question I would like to ask to the author, and Igor's other points that have been already been made, I wonder if you could expand on this turn by setting a kind of triangulation between critical theory, systems theory, and emerging law and political economy, especially in its current European version. And you don't seem really interested in this debate in this book. However, I wonder if the strategic value of societal constitutions can really be limited to the formalism and does not actually offer something more to Christodoulidis' project, especially when it comes to what he calls strategies of rupture and the link to the practice of negation. To make an example, societal constitutionalism has explored, or at least showed some interest in the strategic use of the legal right of resistance in setting the stage and stabilizing the emergence of the contradiction, of the dissensus, of the form-giving event through which the political subject may at the same time create itself, protect the institutional achievement of the political constitutionalism while at the same time contributing to the constitutionalization of transnational regimes. Even the mass strike, that has so much relevance in this book, has been often conceptualized through the lenses of the right of resistance, the legal right of resistance. And I wonder, whether this interest in laws on rupture for its self-transcendence keeps societal constitutions within a Luhmannian systems theory is a different issue. But I think it's a point worth making. In the same direction, I would like to point to the relatively selective use of systems theory, as the author has clearly disclaimed. This is not something new or surprising, and it's not problematic per se, but I would like to problematize the way in which the Redress of Law frames the political and economic systems against each other. I think the gloomy picture of global capitalism and market thinking is quite, I would say, I don't want to repeat what has been said, but I think it's realistic. Still, it seems to me that Christodoulidis denies the economic system the flexibility and inner transformative capacities that even Luhmann recognized to it. In a way, Christodoulidis becomes more Lumanian than Luhmann himself, especially when it comes to the distinction between code and program within the economic system. At the same time, the political is depicted in a somehow idealized way, which brackets the inner compulsion to the accumulation of power. The main target of Christodoulidis' work is market constitutions, that's for sure, but the inner expansive tendencies of the political system as such do not seem to really enter the picture. If we follow Luhmann, the code of political system remains superior inferior. And the author takes the political system and pits it against the economic at an already constitutionalized stage of its evolution. And this emerges also in the fact that this concept of the political definitionally and uncontroversially incorporates democracy. One is left wondering what exactly Christodoulidis' notion of democracy is. The use of Luhmann, a point that is never really directly clarified in the book. The use of Luhmann is very selective, and this results in a subtle surgical replication of Luhmann's functional synthesis between the political, here depicted as uncontroversially democratic, and constitutional law. Only in this way can the constituted dichotomy be represented as foundational of political constitutions, because the constituted is already there as a given. Now, the eclecticism of the redress of law is one of these many merits. And thanks God, Luhmann can be wrong. But the selective use of systems theory here results in the absence of any problematization, of any critique of politics as such. Can there really be a critical theory of constitutionality that does not focus on the power politics complex as such? This removal is particularly apparent, I would say, when it comes to the consequences of the fatigue of power, that is, the increasing difficulty under conditions of functional differentiation for the political system to generate consensus-based, collectively binding decisions with consequent internal tendencies to oligarchization and systemic corruption. The political system too has these inner tendencies to overdetermine the future, even in constitutional terms. Wasn't Pinochet's cheating constitution still a manifestation of the political but undemocratic rationality? Or it was only a case of economic capture? Likewise, the distinction internal-external is also exploited not only by market constitutionalists, but also by political constitution, by the political system, through the competitive, the selective withdrawal from normative systems that would limit the uncontrolled reproduction of power. Similarly, the generation and management of ever newer crises is dictated also by political rationality as such. Creeping deconstitutionalization trends due to the pandemic governance are not, or at least not only due to the economic rationality. Scarcity may be created not only by economic systems and markets and capitals, but also by power imperatives. Can we really argue that the global food crisis that we are facing right now due to the war in Ukraine is only due to the interest of the military industrial complex, or not also by the role of nationalist internal political elite within political systems? This sanitized picture of the political, I would say, results on one hand in the absence of any problematization of the concrete historical experiences of socialist countries, especially those that started with auto-gestionnaire understanding of the political. On the other hand, it results in the relative indeterminacy of the concrete strategies proposed, which mostly focus on strike and social action in public interest litigation. Even if it's not a programmatic book, of course, it has a royal, I would say, disinterest for the how of the exercise of the constituent power, the politics of the present. On s'engage et puis on voit. If the author thinks, as I understand, that there cannot be or should not be any pre-imposed how to constituent power, at least to evaluate it ex post, then isn't his position on a collision course with critical global South thinkers? Well, I here only want to support the point made by Camila Vergara, at least to some extent, when they focus on the procedural and substantive conditions aimed at enhancing deliberation, Here, even Habermas could have some points to score still today. And I say this as a human. Now, legal pluralism, and I'm going to the end. Only by presenting this sanitized concept of the political, can Christodoulidis see monism as a guardian of constitutionalism and the pluralist discourse exclusively as a watering down of the controlling functions of constitutional normativity. He describes the pluralist discourse as hopelessly captured, co-opted by market thinking, and as a way for the economic rationality to escape a solid constitutional normativity. I wonder whether this book takes legal pluralism seriously. So it's true that the constitutionalization discourse has indeed been co-opted by, and to some extent is the result of marketing. But I would like to problematize this stark contrast between the allegedly watered down, fluffy constitutionalization discourse and this rigid dichotomy between constitutional and unconstitutional. I think if you take pluralism and constitutionalization discourse seriously, they work at different levels of analysis. Here I want to go back to systems theory. Seems to me that the constitutional and unconstitutional dichotomy is a binary code that still operates at the level of the single operation, at the level of the basic self-reference. While what the discourse over the constitutionalization or deconstitutionalization tries to capture is what happens at the level of systemic self-reference or self-reflection. Here, the distinction between code and program comes again. You discussed this point several times, but I think the focus is only on the role of values as goal-oriented programs providing negative links to the variations in the validation of the basic code. And so you operate two reductions. You first reduce programs to values and the latter to their negative side as blocking devices. And seen from this perspective, pursuing a strategy of formalism and defending the rigidity of the constitutional and unconstitutional distinction as such, valuing only its blocking function while ruling out informal law and pluralism, does not assure much in terms of actual constitutionalization. The Jim Crow's laws in the US, validated by the US Supreme Court, were clearly constitutional. And that was based on a clearly strong, rigid dichotomy based on the constitutional and unconstitutional distinction. Still, it resulted in a deconstitutionalization process within a political, not at least also political constitutionalist experience. And in this regard, I would say that De Sousa Santos, in his valuing of legal pluralism, is quite not mistreated, but I think the book could have engaged a bit more with De Sousa Santos and how he really takes pluralism on its own terms. I would have other points, but I want to
2 minutes.
Yes, 2 minutes is enough just to make a final sugary point. I would like to end with a consideration not immediately related to the content. So I think this book is a testament to what I would call the beauty of unmarketability, in the best sense of the word. There is a certain style, I would say, a certain aesthetics that is already in itself a critique, an act of resistance to market thinking in this book. And the arguments unfold patiently, slowly, and the careful, detailed deployment of interconnected, symmetrically disposed arguments, the navigation of this impressive amount of lines of thought, approaches, theories, coming from law, philosophy, sociology, economics, is an act of resistance in itself. These internal connections and symmetries across chapters are absolutely necessary to capture the real content of the book, which as such cannot be broken down into standalone units, cannot be processed in single pills of content, right? To be digested separately by the academic market. In this sense, cannot be reduced to numbers in the superior way of thinking. All this stands against everything we are told today, especially as early career scholars, I would like to underline, when it comes to the marketability of academic publications. I think this is particularly important to say this here in UK. There is at the forefront of a struggle, of a global struggle, against the neoliberalization and marketization of the academy. I think it's particularly important to say this here. Thank you.
Yeah.
Good. Thanks a lot, Angelo. So what I would suggest is we give the option to Emilios to reply to some of the points that were raised, but if doesn't want to, we will just collect further questions. What do you prefer? I think
It's a nearly impossible task.
yeah. I mean, I'm also to say we have to be aware that in say maximum 15 minutes we have a break.
Okay, so why don't we have a discussion and then maybe
Okay.
towards the end I can also collect my thoughts. We'll have a discussion on the.
Should we take the break now then, and then have a general discussion? Yeah.
Do we have a break?
I think I killed everyone.
So, because we will have a coffee break in say 6 minutes, so we're thinking of taking a coffee break now and come back in 20 minutes and the general discussion. For those who are from this time, this is all right, then we will drink a coffee also on your behalf. Good. Okay, so we reconvene at 3:45. Okay. Good. Okay, hi everyone. We are back. Now the plan is very simple. We will open now the floor for debate. Questions and comments coming from on Zoom audience or from around the table. If you want to ask something from Zoom, just wave the hand, which you can find in the chat function. Who wants to kick it off? So I will take, say, a couple of questions first, and then George.
Thanks. Thanks a lot to all our speakers, which also demonstrate how Emilios's work resonates in different areas, which is really an amazing result. Of course, it is a 600-page long book, so it's nice that it delivers on so many fronts. I just wanted a couple of things. First, something that Camila said about the first point you made. You know, the idea that Emilios seems to be using legal tools or instruments, if you want to say that, to disrupt, you know, the market rationality. Even though you said these are precisely the strategies that were used to enhance market rationality and so on. So I took this point more as an indication that you know, the normative project in Emilios's work is not always spelled out fully. So the way I see it, you know, we have liberal autonomy and freedom, which are reflected in ideas of the rule of law. But there is another dimension, that of, let's call it independence, for instance, which is not just about liberty and autonomy, but also about the conditions of their exercise. So there is this further dimension, which we find, I mean, even in Kant. I mean, Kant, when he talks about self-sufficiency and citizenship, he says that those people who are not self-sufficient, and in those he includes also the contracted labors, such as the I think the wig maker, or the private teacher. He says these are not citizens because they're not self-sufficient. The liberal solution, but I mean, this is an interesting point, because the liberal solution is to call them citizens too, give them rights, you know, give them the sort of thinned out rights, call them citizens, but then of course there are no conditions of exercise for them. And so I think this point is important, but at the same time, and having discussed his work with Emilios, At the same time, you know, even if we want to include that further aspect, we cannot give up on what the conditions of exercise are about, which is, you know, autonomy in some notion, in some, and so perhaps, I mean, here he is to correct me, perhaps ideas of the rule of law, you know, at some point are not enough, or they have been used in different ways, but they say some things behind which we cannot go, because, you know, they are substratum, as it were, for discussing further independence and self-sufficiency and whatever you want to call it. And so I think there might be an ambiguity there in the book about how much you include. And I know from discussions we had in the past that you felt in recent years that, my God, I mean, even this minimal stuff that the rule of law was talking to us about, even the liberals accept, but even that stuff is not being respected these days. So, but I think it is true, and I agree with, that's what I take from your criticism, Camila, that it is not clear the content of the normative sort of context. So that is something that interests me a lot. That's why I bring it up. And the second thing is about Christian, when you propose at the end cooperation as the third way for democratic governance. And it's more about a clarification here, because I'm interested in that. So is cooperation, because there are two ways to understand cooperation. Cooperation might be an enabling factor for democratic governance. So, you know, but then we have to understand democratic governance as being created, constituted, grounded, if you want, or justified before cooperation. So cooperation is, you know, is like the discussion with the basic structure in roles. They say, well, look,
it's contradictory.
Justice
at the moment, yeah.
Justice tells us what we need to do, and then the basic structure is something that we have to create later to enable. And so I wonder, is it a third way, or is it more a way of saying, well, look, if we go down the Habermas or the strength, you know, cooperation is a further bit we need, and it is not constitutive, if I may use the heavy expression.
Yeah.
But that's more to clarify.
Do you want to react immediately?
Thank you.
Yeah, just one word. I mean, I'm following this kind of stuff since I did the studies on comitology. And what was interesting about this was that they did not pretend to have the same kind of situation. The argument is they tried to observe that, and idealize it certainly, that they tried to find solutions which were respected by both politics. That is, it is not, you know, make a deal, but it is to cooperate for a solution which is for both political entities involved acceptable. So all depends on the structure of the interaction. So as I said, it must be deliberation, a deliberative form of consensus or bargaining or what have you. But okay, the problem is indeed the structuring of the cooperation. You cannot simply say let's cooperate.
Yeah.
That is not respectful of autonomy and democracy.
Right.
Other questions? I mean, I have questions, but first I want to collect or you know, comments.
No, say.
Well, I mean, no. So yeah, I mean, I want to insist on a theme that has been already brought up by at least a couple of commentators, and it is again the theme of the capture. Basically, the normativity of the constitutional order by market exposure. And this, I want you to say a bit more how this can still be somehow grasped intellectually by making reference to distinction between normative and cognitive expectations. as I read the way you say graft that distinction, cognitive and normative expectations, onto the normativity of the Constitution, is that fundamentally cognitive expectations respond to something, to signals that come from the environment. That's how I read it. I might be wrong, but this is what I thought you actually implied. Cognitive expectations come from signals that come from the environment that are retranslated into the code of the system in order to, in that case, make the system probably, if I may use this, probably inert metaphor, running. But I wonder, so this, in my view, probably captures a certain reality of European law, and in particular European Union law. I mean, Alan has written a lot on this, with the idea of the governance by numbers, dominance of benchmarking and statistics. But I wonder whether we are at the end of that phase, which brings me to then basically ask you to unpack a bit more that distinction between cognitive and normative expectations. Because I mean, we have kept hearing both from Angelo, from Camila, the idea that this idea to market exposure idealizes a bit the political, and it takes probably in a way that is too monolithic market dominance. And I would say probably when you talk about a particular experience, which is the experience of European integration after the fall of the wall and until very recently, in my view, you might still be onto something in terms of capacity of capturing constitutional reality. But I wonder whether we are not moving toward a different phase, which is not anymore a phase of sheer market following or market veneration, but it is literally a phase of market making. So where you basically have, say, I mean, I make an example I'm familiar with. You suddenly have central banks of I would say, most developed, economically speaking, countries, suddenly basically making the market in order, of course, to still be able to say that they are following market signals. But actually, if you look and unpack carefully what they are doing, is that they are basically monetizing debt, and they are monetizing fundamentally a crisis on capital accumulation. But while they are doing this, they are fundamentally making the market by supporting certain economic sectors, certain financial sectors. So putting certain sectors into an advantage, so giving them a competitive advantage. So they are, say, for example, I mean, if you look at the composition of the bonds, both corporate bonds and member state bonds, both by the European Central Bank, you will clearly see that there is a preference. Which of course then basically says at one level, admits there is a recognition that someone has to step in and not only correct market failure, but literally build up the market itself. Now, this, in my view, makes the distinction between normative and cognitive expectations slightly, I'm not say blurred, but slightly less relevant. Yeah. Because you are basically somehow, in my view, pushing a certain level of normative expectations into what you are producing as cognitive expectations. Right? So in the first iteration of market exposure, as you have it in the book, the distinction holds, in my view, because there is still a sense in which markets had not collapsed. And therefore there were signals that you might be able to formalize as external to the system, so belonging to the environment, say the political system, or in that case, the central bank as the institution granting the structural coupling between the economic and political system, are still capable of receiving those signals and make them into and channel them into cognitive expectations. But now they are building up themselves, and they are telling corporations, I won't take names, but say Audi, Ryanair, EasyJet, Thales, they are telling them, don't worry, you don't have a problem with cognitive expectation, because we are going to build your cognitive expectation, because you know that for a certain amount of time, we will clearly buy your bonds no matter what. And even for fundamental member states. I mean, at current point, I think 70% in the last 5 years, 70% of states public debt in Europe, and I must say this is a discourse self-contained in Europe, I have way less knowledge about things that are outside of Europe, are basically being bought on secondary markets by central banks. And this is a way, although indirect, because it is through secondary markets in that case, it is still a way of shaping government expectations. So I wonder what is left in this new phase of that extinction. And if something is left, which probably is left, where does it bring us? In which direction it brings us? I have other questions on different topics. I will leave to Alan.
Yeah, thank you. It was really fascinating, all these comments. I've only few remarks and questions, perhaps. La première sur la force dogmatique des chiffres. L'une des choses qui est parfaitement vue dans le livre de Emilios, c'est la conscience constitutionnelle qu'a pu avoir un homme comme Desrosières dans son histoire des statistiques. Et le chiffre, à la différence des lettres, est lisible immédiatement, universellement, et il ne se prête pas au même jeu herméneutique que les lettres. Et lorsque Desrosières explique qu'au fond, les conventions d'équivalence fonctionnent comme une constitution, il faut voir aussi ce qu'il y a de particulier à ces constitutions quantifiées, c'est qu'elles ne se prêtent pas à une critique discursive. Le chiffre s'impose avec la force d'une image. Et donc, il est au service d'un imaginaire cybernétique dont, à mes yeux, le travail de Luhmann est un des sous-produits, tout en ayant une grande admiration pour l'intelligence et les vues de Luhmann. Il me semble que ça participe de cet imaginaire cybernétique qui est dominant depuis maintenant une trentaine d'années et qui conduit, ça aussi c'est parfaitement montré dans le livre d'Emilios, à des formes de normativité comportementale qui viennent briser la forme juridique. L'exemple de l'intervention de la Troïka en Grèce est un exemple paradigmatique. L'Union européenne, en tout cas l'eurozone, s'est attribué des compétences qui sont totalement au-delà de tout ce que prévoient les textes, au nom de disciplines quantifiées, au nom donc de la gouvernance par les nombres. Le point sur lequel je voudrais insister, c'est que cet imaginaire cybernétique conduit nécessairement à des impasses. Il est condamné à trouver sa limite catastrophique. Les êtres humains ne sont pas des ordinateurs bipèdes et soumis à ce type de régime, leur seule ressource est de faire allégeance au plus fort, d'où le retour massif, me semble-t-il, de liens de dépendance personnelle, de liens d'allégeance, comme réaction immunitaire des sociétés face à la corrosion de l'ordre juridique par cet imaginaire normatif. Ça, c'est une première remarque. La deuxième remarque, c'est la force du formalisme. J'ai particulièrement aimé dans le livre d'Emilios ce qu'il dit du formalisme. Et je pourrais l'illustrer par une anecdote. Les personnes qui ont eu à vivre dans des régimes totalitaires ont très bien perçu cette fonction protectrice du formalisme. Je pense à certains passages d'Alexandre Zinoviev, par exemple, le dissident soviétique dans les hauteurs béantes, ou plus récemment à cette anecdote d'un petit commerçant russe de Moscou qui avait mis un écriteau dans son magasin disant « Non à la guerre ». un retraité qui passait l'a dénoncé à la police est venue le chercher et il a été condamné à une lourde peine financière. Et à la place du écriteau qu'il avait dû enlever, il a mis une deuxième affiche. Il y avait ici un écriteau qui m'a valu 10 000 roubles d'amende. Donc, vous voyez comment on joue sur la forme, encore. C'est un dernier appel à la forme pour éviter la répression. Troisième remarque, c'est sur des points qui ont été abordés notamment par Joerges, mon ami Joerges, tout à l'heure, sur la démocratie économique. Il me semble que les liens entre démocratie politique et démocratie économique ne datent pas de l'invention de l'État social. J'allais dire, ils sont aussi anciens que la démocratie elle-même. Lorsque Solon pose les bases de la démocratie athénienne, c'est pour répondre à une crise sociale majeure et à la mise en esclavage des Athéniens les plus pauvres. Donc, il procède à l'effacement des dettes, il reconnaît la dignité de citoyen. Donc, dès l'origine, démocratie économique et démocratie politique sont étroitement liées. Ça se retrouve dans les cités italiennes de la fin du Moyen Âge. Encore tout à l'heure, je ne suis pas tout à fait d'accord avec ce qui a été dit sur Montesquieu. Vous voyez, je suis toujours un défenseur de Montesquieu, car s'il vante les vertus du commerce, il y a dans l'esprit des lois des pages pour dire ce qui menace le commerce le plus, c'est des différences de richesse trop grandes. Et il plaide pour un système où les plus pauvres peuvent vivre dans la dignité et où les plus riches, je cite de mémoire, sont dans une telle médiocrité qu'ils doivent travailler pour vivre. Donc, chez ces philosophes des Lumières, et vous trouvez chez Rousseau des pages qui disent qu'il faut surtout éviter d'avoir des banquiers à la tête des affaires politiques, non seulement à cause de leurs gains malhonnêtes, mais aussi en raison du mauvais exemple qu'ils donnent à la jeunesse en lui donnant pour ambition de s'enrichir au lieu de cultiver la vertu. Donc, il y avait chez les philosophes des Lumières cette conscience très nette du lien entre la République, puisqu'on ne parlait pas tellement de démocratie, et la donnée économique. Et dans la période contemporaine, enfin au XXe siècle, on doit beaucoup à l'Allemagne, et Christian Joerges a justement rappelé ce qu'on doit, que la notion de démocratie économique, elle a d'abord été forgée par des gens comme Sinsheimer, et elle n'a pu ensuite prendre son essor qu'après la Seconde Guerre mondiale. Et je pense que c'est l'Allemagne qui l'a avancé le plus dans le champ du droit du travail, cette idée. Enfin, je termine par un dernier point qui est aussi une question sur ce qui me paraît être un angle mort dans le livre, mais dans un livre de, je ne sais pas, de 600 pages, quelque chose comme ça, et encore, parce que les caractères sont très petits, on ne peut pas reprocher à l'auteur de ne pas avoir refait le monde entier, mais c'est la question de l'ordre juridique international. Et ça serait pourtant un bon exemple. N'y a-t-il pas eu des efforts à la fin de la Seconde Guerre mondiale pour fonder un ordre juridique sur justement la notion de coopération dont nous venons de parler? La première génération des grandes organisations internationales, que ce soit l'Organisation mondiale de la santé, l'Organisation internationale du travail, le Fonds pour l'alimentation, sont des institutions qui visent à organiser une coopération entre des États qui sont appelés à conserver leur souveraineté et leur indépendance. Et cet ordre international est aujourd'hui dans un état de schizophrénie totale depuis la création d'une nouvelle génération d'institutions, au premier rang desquelles, évidemment, l'Organisation mondiale du commerce, qui ont au contraire comme agenda de soumettre l'ensemble des nations à ce qui serait un ordre spontané du marché, c'est-à-dire en réalité la version sécularisée de la foi chrétienne dans la divine providence, où c'est la main invisible du marché qui a pris la place de la providence. Et nous sommes dans cette situation de schizophrénie, donc ne serait-il pas important dans une réflexion globale sur l'avenir de la constitution politique, de faire place à cette réflexion, non seulement à l'échelle européenne, qui pourra en être un bon exemple, parce que là aussi, on voit bien que l'Europe des coopérations a laissé place à une Europe faisant foi à l'ordre spontané du marché, mais sur un pan plus général. C'est pourquoi, pour identifier cette troisième voie évoquée tout à l'heure par Christian Joerges, j'essaie de défendre la distinction entre la globalisation, c'est-à-dire le rouleau compresseur de l'ordre spontané du marché, et une mondialisation respectueuse de la diversité des cultures et des histoires et qui promet une coopération, qui promeut une coopération entre nations. Il est assez piquant aujourd'hui de voir, par exemple, l'Union européenne ne plus utiliser quasiment qu'une seule langue, qui est la langue du Brexit, c'est-à-dire faisant l'impasse sur la diversité de ses traditions, l'effort qu'il faut faire pour se comprendre, que vous êtes en train de faire, hein, je suis désolé de vous l'imposer en ce moment, c'est une façon un peu pédagogique pour rappeler cette diversité du monde qui n'est pas un handicap pour la coopération, mais qui est une de ses conditions. Donc, j'aimerais bien entendre Emilio sur cette question, sa vision de l'ordre juridique. Il est à refonder cet ordre multilatéral. À l'évidence, il est dans une crise profonde qui a été théorisée par Bush au début des années 2000, qui a dit c'est fini le temps des organisations internationales, nous sommes dans le temps des coalitions. The coalition of the willings était le mot d'ordre de la Deuxième Guerre d'Irak, qui est typiquement de facture féodale, c'est-à-dire le grand féodal lève le drapeau et chacun vient avec ses troupes. Je crois que les Ukrainiens, à l'époque, avaient envoyé une vingtaine d'hommes et le Royaume-Uni des bataillons beaucoup plus considérables. Mais on était, vous voyez, dans une logique internationale qui est impériale et d'allégeance et qui n'est plus celle des coopérations entre nations qui avaient été envisagées à la fin de la Seconde Guerre mondiale. Donc, faut-il faire son deuil de cette aspiration à un monde organisé de façon multilatérale, ou bien notre tâche n'est-elle pas de contribuer à repenser, à refonder cet ordre multilatéral comme condition de démocratie vivante à des niveaux territoriaux? J'espère ne pas être trop confus.
No, that was very good. Thanks a lot. Well, who wants to react? Other questions?
Can I say maybe something and then, not as a final word?
No, don't worry, don't worry.
Okay, I've got a lot to say, and I will say at the end also my thanks for such fantastic engagement. But just a couple of points to what Alain said, and maybe also to what Marco said, and I'll work backwards. But there's something really interesting about this idea of a Europe of cooperation, which involves forms of accommodation of diversity that you would like to call mondialisation, as opposed to the kind of the kind of like Brexit logic, where the only way of accommodation involves national identifications. I wonder whether at the international level, so once one moves up from the national level, because this is what you were talking about, the supranational, you have the worrying phenomena. And I'm not saying that these have to be this way, but we need to be very strategic about how to reverse some of these trends. We have the one situation where competition becomes the principle of accommodation. And typically, as we've discussed, where work, the evaluation of work becomes a variable that is most handy to national economies, the evaluation of labor becomes key. But where there is an extraordinary reversal, where the logic of competition that was meant to, even for Hayek and the others, was meant to serve a social project, is reversed, so that rather than having competition, if you are minded in that way, you might say that competition might serve ultimately a project of a social project, social protection. You have a reversal where any form of social protection becomes instrumental to increasing competition. Menendez makes this point, and I think it's a very good point, the way in which we've lost in this competitive environment, the very thing to which competition, was meant to serve. And then on the international level, one of the kind of things that we have become accustomed to now is, and this doesn't apply to Christian's argument about the conflict of laws. I was thinking more of the kind of argument that someone like Christoph Möller puts forward, where he talks about two ways of understanding the sort of relation between national systems. He says we can have, at the meta level, we can have private law frameworks or public law frameworks of national systems. So there is a kind of sense in which we can either set them in competition with each other or in collaboration, but this again is, and he's quite agnostic about which direction one should go. There is something at least alarming about this kind of discussion, where competition comes to inform the only way in which we can think of the accommodation at the supranational level. Anyway, this is just a comment. Can I just say something about normative and cognitive expectation? I think you're absolutely this fascinating stuff about market making. Now, but cognitive and normative expectations are distinction, as with everything in human, is function. So cognitive expectations are the ones that are discredited when they're disappointed. Normative expectations are the ones you hold on to when they're disappointed. And what happens with constitutions, of course, you have a second order normative expectations. So you entrench things, you entrench normative. All cognition is dependent on relation with the environment. That's not a crucial factor here. But what again is quite interesting in this process is how these configurations of normative and cognitive become rethought in terms of precisely this market making. And one of the arguments in the book is that there is a three-stage co-option that the market inflicts and is relevant here. So at the first level, it collapses the notion of political economy, this is into a market. So any sense of the economy is always already market. The second is a moment of democratic co-option, and here they draw from, where basically politics becomes the accommodation of preferences, and preferences are best circulated in terms of the truth value they get in markets. There is a democratic moment there where the markets move in. And finally, it's a very difficult problem, which involves the epistemological co-option. And this is where the normativity cognition thing plays out most alarmingly, which has to do with this very idea that actually markets, there is an intricate relation between markets and knowledge generation. This is quite important. It's not just the markets are good calculation. It is because markets generate knowledge. They generate knowledge about what is needed and what is valuable. So it's not just they come in to calculate value, they generate value. And at that point, the market becomes the government. I mean, it takes over, even at the level of what counts as knowledge. Valid knowledge. So anyway, this is just it's not a direct answer to market making, but it's in the context of, because we can talk about market exposure and we can also talk about sheltering certain practices from markets, but the question of how you rescue something and protect it from the logic of price is becoming increasingly difficult to even articulate. Not just defend, but even conceptualize. And that is the problem of, I think, total market thinking, is how it works at the epistemological level.
So can I say something about this? So I don't know this discussion very well, but so isn't the point, though, Emilios, that that it is not just that. So the market puts forward, as it were, data in terms of producing knowledge. And I thought your point was that this data is not only not neutral, but it incorporates already an opposite normative project, or a normative project that we could.
And it is not made
Open, clear.
by the market itself, but it's basically built into the market by other actors.
So I took this point to mean that we have to raise a contrary normative vision to the market that is articulated in a clear way. So that's what I mean. Well, I pushed it a little bit now further, but that's how I would see it. So it's not just producing data, which is what is presented as, but it has a very clear normative input to which we must, raise a different, a normative vision that in 39 or 32 in those papers of Hayek was a utopia at the time. And now it's reality. So you have to raise a new utopia, as it were.
But you see,
Yeah.
can I add something on this? Because I think it is a fruitful distinction. I really think it should be upheld. But I was thinking, how does it hold against the idea that despite the fact that cognitive expectations, even those fundamentally granted by market rationality, are frustrated, market actors still know that there is a possibility that despite the frustration of cognitive expectations, they still will get what they want. You see my point? I mean, you know that even though you wouldn't be able to gather on financial markets enough financial support for, say, the liquidity that you need, say, for investment on fiscal, you still know that someone will kick in and make sure that you will gather financial, so that your cognitive expectations have been frustrated, but someone is sure enough in your cognitive expectations. So at that point, I'm not so sure whether the distinction really holds. You see my point? Because there seems to be even almost a normative project which still somehow make the market the final sayer in the process, but the making of it is normative from the end. Because central banks are basically saying, look, you cannot imagine an alternative to markets, but of course, given that they will collapse, we need to show them up. So there's still a sense in which there's clearly a market-driven process, but the price mechanism has been heavily subsidized, as we like this, and therefore heavily, let's say, corrupted, to a point where it doesn't even make sense to talk about frustration of cognitive expectations. You know what I mean? So, do you see? I mean, I'm struggling with that because I think there's something very fruitful there. But and it could be that we are just seeing something exceptional. No, I doubt it. This has been going on now for years. So I know whether some other people have something to say on this. I mean, when Alan.
It's just a follow-up about this question of market and knowledge and so on. The pandemic gave us a good example of what it means, this kind of schizophrenia. Till a recent period, till the end of the 20th century, everywhere in the world, one thinks that the preservation of human life had the primacy over the intellectual property of drugs. And this was reversed at the end of the 20th century. And this experience of the COVID is a good example of this kind of schizophrenia. On one hand, we have the constitutional principle and also at the international level, the constitution of the International Health Organization, telling that everyone has to have access to the drug and to the vaccine. On the other hand, you have the international market of drugs, patents, intellectual property, and as you saw, from an objective point of view, all the human beings have a kind of solidarity in front of the disease. It's a mistake not to permit to the poor in Africa or elsewhere to have access to the vaccine. And it was a position of the Merkel prime minister, and also with Macron telling yes and no, but as usual, not to let the intellectual property to be put aside for having the drugs, the vaccine made in South Africa or in India, where they have a very powerful pharmaceutical industry. So the answer was, one can have charity. We'll give some doses. In fact, the doses they gave was pyramid. And I have many links in the African countries nowadays. And all these countries are really shocked. You couldn't imagine to see this kind of hypocrisy of the North towards their population. And it's a good example of this antinomy between a regulation through international rule and constitutional rule, or either regulation through the market. And in such a case, the market didn't discover anything because we know that for the common good, it would be better that everyone would have access to the vaccine. You see my point?
Thanks, Alain. So, now you have to unmute yourself.
Yes, it's wiser.
No, Sue, you have to unmute yourself.
No,
hello.
but
No, talking about Sue Bian. You're fine, Alain. Fine.
no, it's over. It's finished.
Okay, hello everyone. Hello, Milos. And so nice to see so many familiar faces. And I first of all, I want to say that congratulations on Milos's publication of the book. And it reminds me a lot of the old days. And I came to Glasgow in 2010 when Milos began to write this book. And I remember that at that time, every time Milos wanted to push me to write something for discussion, he would say that, so we'll see who finished first. And well, I think apparently I won the competition. And, but I think compared with someone who has a book that covers so many important things, and also for someone who is devoted to writing, spent 10 years in writing critical constitutional theory. And I think my PhD is nothing. So first of all, I want to show my respect for Milos. And secondly, I do have a little question. And I think maybe someone has already talked about or mentioned about that. And I think, first of all, I think I have learned a lot from this book. I think it's inspiring in many aspects. And I think that although someone says the Luhmann's part is very controversial, but I think I have learned from it, especially when Milos has talked about the adequacy. And he says that, in fact, in Luhmann thesis, about the performance reflection and function performance reflection trichotomy, there's implicit in the system theory, there's a question about the adequacy, and the adequacy can bring about the distinction, can re-enter into the distinction of system and environment, and also redraw the distinction between self-reference and other reference. And I think in that sense, the adequacy is in fact the normative dimension of Emilius's book, which is not restricted to the legal dimension, but something in another level. And secondly, also in the part of market constitutionalism, I think what is insightful is in fact in Teubner's or Luhmann's writings, we see that they're constantly talking about in fact, in nowadays, social integration is already rendered obsolete. What we can only have is the subsystem integration. But in that kind of procedure resolution, instead of the substantive resolution, the Emilius found that there's a magnificent trade-off between the value of equality and non-discrimination. Well, the non-discrimination is a kind of duplication of the value of liberty instead of equality. So I think in that sense, he also tries to find something, although it's implied in the system theory, but also could be turned into critical points. And when I read this book, what most confuses me is in fact the strategy part. And I think that although you have distinguished the three strategies like the militant formalism, rupture, and immanent critique, it seems that the three strategies come to the same conclusion. It all comes to the conclusion of open dialectic between semantics and structures. So for me, that kind of things may be a little inconsistent with the part one when you talk about the critical phenomenology, because when you talk about the critical phenomenology, you want to distinguish Weyer from Arendt's theory, and also you aims not only at the democratic deficit but also at the matter level, at the semantic level. But if you aims at the critical phenomenology, that means you are aiming to distinguish your own semantics from the false disclosure of social phenomena, the originary separation between the political and the social. But when it comes to the strategy of militant formalism, that kind of distinction seems disappear, or I think you are more tolerant towards the other semantics, or I think maybe even ideal discourses could be used as a strategy of militant formalism in a sense. So this is my question, and I think, well, it's still a great book, and I learned a lot from it, and thank you for writing it.
Thanks, Sue.
Yeah, thank you very much. It's lovely to see you. Can I? Yes. Look, the easy answer is that the first part is there to lay open the field in which the fourth part, suggestion, intervention. So there is a kind of, but having said that, of course, the dynamics play out differently. Some bit of strategy may depend on a dialectic, as you say, an open dialectic. Some others have nothing to do with the dialectic. It's about a firm assertion of certain demands on the formalism, so that there is, if you like, there isn't an absolute symmetry. The idea is that if we open up the discussion and introduce a critical phenomenology that maybe finds its privileged iteration in terms of the open dialectic, like Badenfeld's, then maybe that is the privileged way of doing it. But on the other hand, I want to keep for strategy a number of options. That was just my thinking. Just going back to, I mean, one of the reasons, and some of this is just not willing to give up certain things that could be useful to people in desperate situations. And I come back to comments that have been made by a number of people. You know, if you're in the Gulag or in Guantanamo Bay, whatever the Gulag, the last thing you want to renounce is formalism, in the sense that anything that gives you a possibility, anything that gives you leverage may be useful. The same goes for social action litigation, the same goes for public interest litigation. There is no reason to throw away these devices in the name of critique. So that in that sense, this is a more pragmatic route. And I also use systems theory at that point to say, look, to the extent, and this is much more Teubner than it is anyone else, to the extent that Teubner suggests that systems can engage at a reflexive level to limit themselves, yeah, a move of self-limitation. Maybe formalism is useful there, because then you can withdraw certain things from the logic of the market and the logic of price. You can say, well, this is what properly understood juridical reason is about. Yeah. So there is a kind of moment of self-limitation there against the expansionism. Remember, because one of the interventions of systems theory quite recently has been against the expansionism of any one differentiated subsystem at the expense of the others. There's an argument there about functional differentiation. There's an argument about protecting the integrity of spheres. Yeah, and that is useful. Again, that is potentially useful. So that was the argument there. I'm conscious that shall I just say a few more things?
No,
or do
let's
you
see
want
that there are other interventions. I mean, I'm not that George also wants to say something else. Other comments? I mean, Stephen?
So, Milios, one of the things in the book that stood out to me was this call to maybe look to the past for examples of where there's been solidarity, or there's been the start of a pushback against this capture. And the examples that I can sometimes think of are places where law hasn't been called upon. Law hasn't played the role, because sometimes law can be really divisive in a situation. I'm wondering if the role of law here is instrumental for strategic purposes, or if law is needed for peaceful, fulfilled, flourishing human community, and what form law takes, or is law in this way playing a very functional strategic role at different historical moments to provide protection? Because obviously law can have disruptive effects on society. Just one of the things that cropped up from the thing.
So are you asking this because it looks like law kicks in at the moment of conflict, so it already presupposes some breakdown of the social
yes, so law is less of a guide at that moment, but more of an arbiter. And it's just because the idea of redressing law, I thought the redress of law, like obviously it's got a corrective sound to it, but the image, some things that I had, and that's why I was asking you earlier about the artwork, was like, is there also an attempt here to like redress law from the critical perception of it being just captured and always being used instrumentally for dominant economic destructive means for what might otherwise be flourishing? Are we redressing law with this project in less strategic ways, and ways that actually no law is part of our flourishing?
Yeah, no, thank you, Stephen. I think, yeah, so I've got a bit of introduction where I say we can the title plays on the double sense of the connective of. So there is a redress of law, so how law might redress injustice in society, but there is also an attempt to redress law as the way in which, you know, what we have as a means to do that. So the all is in both senses. So yes, I haven't thought of it in the way you put it. I think my answer is yes. And there is an attempt also, I think, to withdraw law away from sort of just a mere instrumentality, and to say it does have the resources, and that these are valuable resources. I mean, you mentioned solidarity, but that's clearly one, solidarity and dignity. The Charter on Social Constitutionalism that is very much about that. So how does one rationalize the resources that as values stand behind programs, this goes back to the Angelo, to rationalize the field in the way in which the constitutional function may be understood, let's say, properly. So there's that sense too. Right? So law as a means of redress, but also the redress of law, of the thing itself. So the reflexivity of law, I mean, Sue mentioned this distinction that Luhmann draws, the reflexivity of law is how the law thinks about itself. Yeah? So how is that inward move? How does the law, there's a very, very famous paper by Toybert called How the Law Thinks. And if you like, and this became a hugely important paper at some point, people are saying, no, the law doesn't think, people think and all that. But there is an interesting provocative thing to say this is meaning construction, this is how the law thinks. I think reflection is how the law thinks about itself. Yes, so that's recursive. I think it's part of redress.
Yeah.
So we have Camila and then George.
Yes, thank you. I have a two-finger on that. I thought the redress of law was tied to Tavner's idea of the political as the basis of reflexivity. And you pointed in page 477 that you wanted to recruit this constituted reflexivity in order to guide the extraction of some of the parts of the market out of the price and selective withdrawal of certain areas of social action out of the price and kind of like decommodify, right? So it's how law is scrutinized from within, but not unable to modify what we think it is part of it is constitutional, basically, right? So how do we do this? Because one of the problems that at least I think of it in practical terms is that who are the interpreters of law are lawyers. The juridical world is not really connected to the normal world, to the reality, right? And we have, at least as I read Alexei, and his idea is that at the end, what is most important is the interpretation of constitutional law, of the higher law, right? Who is interpreting this? Because at the moment of interpretation, there's politics. There's not really the juridical in a way. We can do kind of a game, but it's always in reference to something that is not really there, is outside or above or whatever. So would it be part of this political constitutionalism bringing other disciplines to bear in the interpretation of law when the moment comes? Because if we want to withdraw some parts of social action from the market, we need to, it's an active thing. It's not negative as you would have it like the limit of blocking and vetoing the erosion, but actually an active thing, because we are past that point, right? We have commodified life too much. So how can we pass from the negative blocking to the actual doing and bringing the political at the real basis of this reflexivity? Yes, that's my question.
No, that's very interesting, Camila. Can I just answer that? And I also wanted to refer to a couple of other points you made, but let me take this one. I don't, and as a Chilean, you will have been exposed a great deal to Alexei. Sorry about that. Yeah, and the proportionality thinking. But I suppose without going too deep into systems theory, you can keep both those things alive. They're not necessarily contradictory. So my argument is that political constitutionalism depends on the constitutional distinction. The constitutional distinction is between clearly the pole of the constituent, which is political and democratic, and the pole of the constituted, which is the material of the constitution as we know it, the constitutional system. But for systems theory, the observation comes from the one pole, from the pole of the constitute. It is just that the political, which is an environmental law, if you like, is the thing that pushes or inspires or draws out. It provides a kind of impetus for constitutional thought. So you're absolutely right in saying that there is an element of politics there, but it's an element of politics that for at least systems theory is always filtered through law. But it keeps alive, if you like, the moment of law that orients it, leans it in the direction of democracy, enactment, political commitment, constituent power, the Republican source of constitutional thinking. I don't know if I've answered this, but in the way in which the constitutional question is approached in the book, which is unapologetically systemic, and we may disagree there. You may say, well, that's the wrong way to go about it, and fair enough, I'll leave that state. But if one takes that view, then the constitutional language is a very language through which the idea of the constituent is expressed. So the constituent isn't expressed as pure iteration, it is expressed as constitutional iteration. Okay, but it's still there. It doesn't disappear as the sort of, is that okay? So that is how I would suggest it. Now, the other thing that Luhmann offers us, I think, is the idea that this is not just judges speaking, that legal communication is the communication that uses the legal code across society. So legal communication is not the privilege. Of course, there are privileged sites where law reproduces itself in courts or in parliaments. The legal communication is a communication that thematizes, that is thematized because it is coded as legal or illegal. It is some communication about the distribution of those values. And that spreads law across society. Yeah? There is a kind of sense in Luhmann that this is spread across society. We talk about the Constitution. Going back to the point Angelo made, the Constitution invites people to interpret it and resist its violation. Yeah. So there is that is a democratic moment of the Constitution because it is spoken by those entitled to speak it. Yeah, who is everyone, the citizen.
Okay, so we have last round of comments by George, Angelo. Is there anyone else from Zoom who wants to ask something or make a comment? Otherwise, after these two questions.
Can I also ask a question?
Okay, so well, let's start from Nicholas, who hasn't spoken yet, and then George, and then Angelo. Nicholas.
Okay, first of all, it's very nice to see you all, see familiar faces, and congratulations to Emilios about this significant book. I would like to ask a question to Emilios, comparing the previous work of Emilios. I see that there is in this work a more relational approach with regards to the relation between constituent and constituted power. That's my impression compared to the previous work of Emilius, which focused mainly on the fear of substitution of the constituent by the constituted. Is that right, Emilia? That's my.
Yeah, it's a fair observation.
Well, and then why so? Can you tell us?
Well,
What has changed?
You want to
First
say
book to
become
this
more
one?
conservative.
Yeah. Okay. Good. Okay, George, and then Angelo.
No, but he has another.
Ah, sorry.
That was a preliminary.
Oh,
No. That was the
No,
question, and I.
Okay.
Yeah.
That's why you
so the answer is that it is getting older. Okay. That's an answer. George and Angelo.
So I'm going back to Sue's question. I don't know if she's still around.
Yeah.
Oh, yeah. About so this idea of critical phenomenology. So I'm going back to the fundamentals, but I'll put it in ways that succinctly. So I think one thing that I think the project has is this kind of normative quietism. It doesn't want really to take a position, a normative position. And I think critical phenomenology as the foundation, of the methodology. So I wanted to ask, why critical phenomenology? Because you have the critical bit from Marx. Marx has an implicit normativity, and you need probably something else to complement it to bring out normativity. Phenomenology is not the place to get normativity out clearly.
Yeah, well, that's what's critical.
But the critical bit leaves open a few questions about what is the guideline of the critical bit, because phenomenology is struggling a little bit for.
Well, the critical phenomenological point is the point about, well, if you are guided by a normative agenda, and I'm surprised you call it normative quietism, but anyway, I'll take it. Even though most of what drives me is anger, most of it.
that should be purified. Yeah.
There is a kind of the point about the critical phenomenological moment is how do you force certain things that are typically not available as disclosures? So how do you force appearance? How do you make something visible against the dominant way of seeing it? So that, in a nutshell, is what the critical phenomenology is doing. You're right, that it's not. We can have a long discussion whether the later works of Husserl, there is a more of a critical moment. It doesn't really matter. I think that Marxism is a phenomenology. And you may disagree with that, but at some level it's a phenomenology. But I think the 11th thesis is an invitation to phenomenology, how to make things rational. And so I think to that extent, now, probably a lot of phenomenologists would not accept this, but there is within the phenomenological literature and at least one current of it that introduces a more, if you like, socially weighted phenomenology. One that is not so much about what appears, but what is, under what conditions does something appear to someone. Yeah, and in that moment of appearance, the appearance summons the subject, and there's something interesting in that, especially when it comes to Marxism.
Yeah, but also a bit something dark, obscure, in the sense that when it appeals to the collective mind, as it were. This collective mind of how it appears to a community is. I think this is a problem because phenomenology struggles between realism, the idea that the world is there, and we shouldn't have a gap between how the world is and how we perceive it.
Yeah.
And then an idealism. Yeah. What are the standards of cognition? Yeah. But it never spells out the standards, really, because it's all about, there's a collective mind, then Husserl goes back to the community, then there's hermeneutics. But it's all a bit, so what is this thing that we, reflect on and guides us in bringing out what hasn't appeared.
Yeah.
I mean, there is a bit of that, you know.
I mean, let's.
So-
it's a very difficult
I
discussion.
just wanted
perhaps,
to, okay, yeah, that's it. But in the history of ideas, I think this turn towards phenomenology in legal theory, why not towards, I don't know, putting Marx next to, I don't know, to Kant, or you know, next to Wittgenstein or Aristotle, but next to phenomenology. I mean, in the sense, I know that Hans has pushed this line a lot.
Well, not Marx. Only
No,
phenomenology.
only phenomenology.
Only-
Yeah, that's true. But I
No,
think
there are
there's a
Aristotelian Marxisms and
Yeah, yeah.
Kantian Marxisms, you know, and this is a phenomenological Marxism. I'm not saying it's standard, but there is, you know, even in this idea of bringing the phenomenon and the receiving consciousness together, so there is no gap. There is something hugely interesting about class consciousness there. You know, there are ways to read really interesting answers from phenomenology into Marxism, and you know, I think there is, it is right. Some very often in spite of Husserl, and very often, you know, a lot of it is in spite of the theorists. So it's a kind of slightly deviant readings, and usually selected for strategic reasons. Yeah, and I may be wrong.
Angelo?
Yeah, two very little points. One is to, in a way, intervene in the last interaction between Camila and Joerges. There's this quite recent paper in by Teubner in the Societal Constitutional Literature that talks about strategies of self-limitation of the legal system. It talks about constitutionalizing de-juridification. And I don't want to combine two mutually reducible positions there, but I think there's something there that can be used from I mean, this is paradoxical, of course, because this strategy uses the constitutional and constitutional distinction to strategize the retreat of law and the juridification of social life, right? And this goes a bit in the direction of what Camila was saying, if I understand her, to avoid the colonization of the political struggle, basically with the legal code, and this plays with I think the very fine line that we drew between formal and informal. I mean, I want to draw on a practical experience here, and maybe you have heard of this kind of landmark case in the climate strategic litigation last year, this Milio Difensi versus Shell case, where a Dutch first instance court basically used a tort law, domestic tort law provision, and one of those very open tort law provisions to fill it in with business and human rights soft law, non-binding norms directed to business corporations, with binding international law, binding only states, plus reports and scientific knowledge generated by institutions of global governance. This big SAL was used. It's a normative SAL. This is formalist or non-formalist. I mean, this is the question. But still, and so that would be the first question. The most interesting part for me is that how this trick is used to thematize a political question at global level that cannot be thematized as political under current conditions of globalization, and using the legal illegal code by strategic, I would not dare to call them democratic. Is this democracy? Is this, I would say, still political, but democracy, I'm not sure about that, for example. And it's brought as a strategy to thematize and to put on trial not just an actor, but a social process, a business model. If we read the motivation, the reasoning of the decision, with the final obligation of itself to and a best fourth obligation to limit the use to limit gas emission by the final users, the customers of Shell. It's the business model of oil and gas industry that is put on trial. And this is hugely interesting for our discussion here, because I mean, in a way confirms the points made here, several moments, but at the same time blurs the lines and the distinctions that are he loved it. I love. I mean, and there's a very nice not paper, blog post by Joerges from a societal constitutions perspective on that case, and it's really
On which blog?
the classroom school.
Good, good stuff. Okay, so I think it's time to wrap it up. Emilios, your final
Okay.
words.
My
You
final
have,
words.
Let's say
This has
12
been-
minutes.
Okay, this has been fantastic. I want to accept much of what was said by, especially by the three respondents of the afternoon, and of course, Alain in the morning. I particularly want to accept what Angelo called the sugary points. But let me, I think, I'll just go over a few points that were made in the afternoon. Thank you, Christian. The point about knowledge and markets, you're absolutely right. It's what concerned me most, and I have learned a lot from your work. And I sort of covered it in this idea of the informational argument from Hayek, how important it is, as you say, to look at the market thinkers in their best moments, as opposed to the kind of awfulness of some of the literature. And there is something still of a great challenge. I think there's a great challenge. And of course, as you know, I take some of your militant formalist arguments very seriously about protecting democratically enacted laws. Camila, thank you very much. I think we disagree less than you think. And I say this because the arguments about homology and deadlock were arguments that we agree on, because those were profoundly problematic moments. So this idea that law takes everything and turns it into a stream of reassurances, which is a homology argument. The idea that, say, the Constitution of Chile actually locked into place certain provisions that made them politically unaddressable. Those are precisely the problems of formalism. And I want to agree with you there completely. If there is some value to formalism, and I won't go over the stuff we discussed just now, it is in those moments when where it gives you an argument that gives you some leverage in situations of profound injustice. Now, and I really appreciate much of what you said about both Epikuros, of course, and the swerve. It's fascinating stuff, as well as the idea of the event. There is a hugely interesting idea about an event that breaks into the real, where the conditions of its emergence are not available, in a sense. Yes, so so there is a kind of, there's something really interesting in this form-giving moment. And you're right that maybe the later Rosa, with the council's discussions, much also closer to the kind of argument I make about solidarity. And of course, I'm sorry I missed that connection, that Polish connection too. However, the point about the mass strike, what's interesting about the mass strike as a moment of rupture is that by completely withdrawing, that moment of withdrawal is a moment that cannot be thematized by the system. That's what's interesting. Because there is no room for co-option. And that's why Sorel loves it. And that's why Benjamin loves it. And there's something in the mass strike, that very early text of 1905, that actually captures something about the fascination with this moment that is pure negativity, it is pure withdrawal. And if it's pure withdrawal, it cannot be given significance in terms from the point of view of the system from which labor is withdrawn. I'm afraid we're going to forever disagree about Arendt. I'm sorry about that. I know that what you're talking about in our revolution, she talks about the council system, but doesn't know what to do with it. I mean, there's five or six pages where she marvels at the moment of solidarity in the syndicalist movement, but then leaves it because she's actually ruled them out as a political project due to the stringency of her distinctions. So she doesn't really know what to do with syndicalism as a political project. She just writes really well about her excitement. But okay, well, I have the last word, so I can say that. And again, without the Sir Machiavelli, you're right again about the discourses. What interested me about Machiavelli was really Althusser, not Machiavelli himself, and because he is a structuralist who is really struggling with a bit that cannot be structurally predetermined. That's what's beautiful about such a late text. He doesn't know what to, Machiavelli poses for him, a real problem, a challenge that because he's such an astute theorist, he can't ignore, but he doesn't really know what to do with it. And there's something fascinating about the aperture, especially from a Marxist, from a structuralist Marxist. So that was more what attracted me to that. But anyway, thanks very much. And Angelo, I can't, there's far too many things about which you're right. So one of the problems is, of course, that labor as a lever for everything does leave me stranded in some kind of 4 decades ago. What I would like to say, I mean, I'm fascinated by the critical turn in system theory, but I think that it's far too easy. They've suddenly discovered, I mean, that there is a normative dimension to systems theory that's been imported slightly on the back of other things. Fischer-Lescano talks about the critical term. Kogan talks about it. I don't see it. I mean, I see that it's normatively significant, but I don't see the depth to critical theory that would have made it possible. That's my problem. Right? So I see, of course, and I think there's something really important about turning some of these insights against Luhmann and against some of his priorities. What I don't see is, what I find difficult to work with is the profound forms of inertia that system theory brings in terms of the kind of observation it makes possible, how these can suddenly turn critical. So I'm just worried that it's a little bit too quick. I think you're absolutely right about the right of resistance. There's something paradoxical, but hugely productive by the fact that the Constitution is a document that opens itself up through the right to resistance to the illegal, or to something that, here is the apex of the system that gives you an opening to resist the exercise of political power. So it's a rather, I know you've written about this, but it's an extraordinary moment of openness and radicality in a text. It's all about closure, and it doesn't quite know what to do with this opening, but it's definitely very interesting. And finally, though you made, I'll accept everything you said about intersectionality, and you're right, and space, but the only thing I would like to say about politics, I mean, there is something so profoundly depressing about Luhmann's analysis of the political system, and especially the early stuff on the critique of the welfare state. What I have tried to do is keep from politics as defined as definition of politics, the reflexive question. I did this in my PhD, but so this idea of what is politics is a political question. And this brings reflexivity into the very heart of the politics. It's the same with ethics, I think. So politics and ethics have this reflexive moment that's constitutive of them as a system of meaning, I think. In a way that's not true of the economy, which is about the discourse about pricing, and it's not true about law, which is about the attribution of legality. So the coupling between the legal and the political system creates, I think, in a way that it is accommodated in constitutional language, of course, does produce what we are told it produces in terms of the couplings. But politics is bigger than that. I think it's more important than that. And that's why I typed democracy and equality. I like this moment of time, saying if you don't think that politics is about democracy and you don't think that politics is about equality, you don't quite understand politics as a system of reflexivity, one that constantly returns to ask itself what it's about. That's a very undermining, but it's very bad. It's nice. Not illegal. Okay, so I'll leave it at that. Thank you very much. It's been a fantastic privilege and lovely. I want to say something.
Now, just I am I think the oldest PhD student of yours here, because Emilios was my supervisor. And what he told me before the Viva Voce, and which I pass on to my students these days, is, you know, when you defend, be firm, do not concede points, because if you concede them, you have to change. And the PhD. So I think you've conceded a few points now, especially to Angelo. Thank you, Mila.
Thanks a lot. Online. Well, thanks also to all who were here. And in particular, thanks to the commentators. I think Camila Vergara, all the others are here. Thanks a lot. And well, I mean, that has been nice. I might get in touch with a few of the commentators later on for short written comments for our journal, which is Jurisprudence. Anyway, thanks again. Stay all safe. Ciao.